Welcome to Crime Line. I'm David. Today, we're examining a case where a mundane disagreement, a fleeting moment of irritation in a place designed for entertainment and escapism, escalated with shocking rapidity to a fatal encounter. On January 13th, 2014, within the darkened confines of a Florida movie theater, 71-year-old retired police captain Curtis Reeves drew a concealed pistol and shot 43-year-old Chad Oulson, a husband and father. The identity of the shooter was never in question. The weapon was immediately recovered at the scene. The agonizing question that tore through 8 long years of legal battles, public debate, and personal anguish wasn't who done it, but a far more complex and divisive why. Was this a sudden, inexplicable flash of anger over scattered popcorn, a trivial annoyance blown tragically out of proportion? Or was it, as the defense would passionately argue, a terrified elderly man's desperate, last resort act of self-defense against a perceived imminent threat? January 13th, 2014 began as an ordinary Monday. Chad Oulson, a man who had formerly served in the United States Navy, was enjoying a day off. He worked a Tuesday through Sunday schedule as a finance manager at Sky Powersports, an ATV and watercraft dealership based in Port Richey, Florida. An avid and skilled dirt bike rider and motocross enthusiast, Chad was also a devoted family man, particularly to his 2-year-old daughter, Alexis. On that particular Monday, Chad's wife, Nicole, then 33 years old, had also taken the day off work, specifically so she could go on a special date with her husband. The couple left little Alexis in the care of her daycare and headed out for lunch, perhaps some leisurely shopping, and afterward, they decided to take in an afternoon matinee at the Cobb Grove 16 Theater in the suburban enclave of Wesley Chapel, near Tampa. The film they had chosen to see was Mark Wahlberg's latest action flick, the war drama Lone Survivor. Elsewhere near Tampa, that same morning, another couple were making similar, innocuous plans for an afternoon at the movies. Curtis Reeves, a 71-year-old retired and highly respected Tampa police captain, and his wife Vivian also intended to see Lone Survivor. Their plan was to meet their son, Mark Reeves, who had proudly followed in his father's footsteps and was also a serving police officer in Tampa, at the early afternoon viewing. Curtis Reeves had a long and notably decorated career in law enforcement, a path that saw him rise through the ranks in roles from a street patrolman to a seasoned homicide detective. Before finally retiring from the force in 1993, he had made a significant mark by establishing the agency's very first SWAT team, a testament to his leadership and tactical acumen. After his retirement from active police duty, Curtis had accepted a prestigious position as the director of security for the popular theme park Busch Gardens, a role he had also since left by the time of the incident in 2014. Curtis and Vivian Reeves also had a daughter, Jennifer, whose own young daughter was their only and deeply cherished grandchild. She was, by a poignant coincidence, just over 2 years old at the time, much like Chad Oulson's little girl, Alexis. Two families, unknowingly on a collision course, were seeking a simple afternoon's entertainment. The Oulsons arrived at the Wesley Chapel Theater first. They made their way into theater number 10, which was showing Lone Survivor, and selected their seats in the second-to-last row, a popular spot centered in front of the large screen for optimal viewing. After settling in, Chad, like many moviegoers, left briefly for the concession stand to grab some snacks for them to share during the film. Meanwhile, Vivian and Curtis Reeves arrived, separately from their son Mark, and found their own seats. On their way into the theater complex, they, along with all other patrons, would have passed a clearly posted sign instructing patrons not to carry concealed weapons, knives, or guns into the premises. Curtis Reeves, however, as a deeply ingrained habit forged over his decades in law enforcement, a profession where constant vigilance is paramount, habitually carried a .380 semi-automatic pistol concealed in his right pocket. The Reeveses chose to settle into the very last row of the theater, their backs against a tall dividing wall, placing them directly behind the Oulsons. Vivian Reeves sat immediately behind Chad Oulson, while Curtis Reeves's seat was positioned directly behind where Nicole Oulson sat. The seating area located behind this last row was designated for a bistro-style service and had a separate entry and exit point. As the lights in Theater 10 slowly dimmed, a customary pre-movie courtesy message played on the screen, politely reminding everyone to turn off and put away all cell phones and electronic devices. The trailers for upcoming films and various other advertisements then began to illuminate the large screen, the typical prelude to the main feature. The events that unfolded over the next few tense and ultimately tragic minutes would be rehashed, analyzed, scrutinized, and debated repeatedly by numerous fellow moviegoers, individuals who would later become reluctant but crucial witnesses in court, over the subsequent, protracted years of legal proceedings. In the darkened theater, Chad Oulson took out his cell phone. He was, by his wife's later account, messaging his daughter's daycare to check in on little Alexis before the movie officially started. Apparently, he also took a moment to check Facebook and browse some other random items on his device, the bright screen a small beacon in the otherwise dim auditorium. Catching the distracting glare from Chad's illuminated screen, Curtis Reeves, seated directly behind him, leaned down and, according to most accounts, asked Chad to put his phone away. Chad Oulson, reportedly, refused this initial request. Annoyed by the continued phone use and the refusal, Curtis Reeves then made a decision that would set the tragedy in motion. He got up from his seat and left Theater 10, his purpose being to find a theater manager to make a formal complaint and to have the theater's cell phone rules enforced. He located a general manager, Thomas Peck, and spoke with him briefly in the lobby, lodging his complaint about Chad Oulson's phone usage during the previews. Thomas Peck, however, for reasons that would later be questioned, chose not to return with Curtis Reeves to the theater to address the issue directly with Chad Oulson at that moment. When Curtis Reeves returned to his seat in the theater only a few minutes later, he found that Chad Oulson had, in fact, put away his phone. The immediate source of irritation seemed to have been resolved. The incident, one might assume, appeared to be over. But this, unfortunately, and with tragic consequences, is when the simmering confrontation truly ignited and escalated with terrifying speed. Words were exchanged between the two men, the exact nature and sequence of which would be heavily disputed. Perhaps Curtis Reeves, still irritated by the earlier disrespect and Chad's initial refusal, pushed the issue and prodded a response from Chad, getting in at least one last critical jab at the younger man for having had his phone out. Or perhaps it was Chad Oulson's own pent-up frustration and anger at being told what to do, at the older man then reporting him to the manager like a misbehaving schoolboy. That simply boiled over. Or, most likely, it was a volatile and combustible combination of reactions from both men that occurred simultaneously to rapidly and dangerously intensify the already tense situation. Suddenly, Chad Oulson stood up from his seat. He then, in a gesture of apparent anger or derision, grabbed the bag of popcorn from Curtis Reeves's lap and threw its contents directly in the retired police captain's face. According to Curtis Reeves's later testimony, the older man was hit not just with a light, buttery popcorn, but also possibly, and more significantly, in the head with Chad Oulson's cell phone, which he claimed was either thrown or came loose during the popcorn toss, allegedly knocking his glasses from their place on his head. A moment later, a heartbeat later, before the scattered popcorn even had a chance to hit the ground, Curtis Reeves, a man trained for decades to react to perceived threats, pulled his .380 pistol from his pocket and fired a single, fatal shot. The bullet struck Chad Oulson squarely in the chest, but its devastating path didn't end there. It also tore through Nicole Oulson's hand, specifically through her ring finger, as she instinctively reached out towards her husband in that chaotic instant. Curtis Reeves was not the only individual in the theater that day to have disregarded the posted no weapons policy. As it happened, off-duty Pasco County Sheriff's Deputy Alan Hamilton was also in attendance, sitting with his wife, Angela, in the same back row, only a few seats down from the Reeveses, when the shocking shot was fired. Deputy Hamilton also had his own firearm with him, tucked away in Angela's handbag, but thankfully, he would have no cause to use it. Immediately identifying himself as law enforcement amidst the ensuing panic, Deputy Hamilton quickly moved to secure the pistol from Curtis Reeves. Reeves, after firing his single, devastating shot at the Oulsons, had reportedly sat back down in his seat. Some witnesses later described him as appearing strangely calm and had placed the weapon on his lap. Chaos erupted in the darkened theater. Many terrified moviegoers rushed from Theater 10 into the lobby, desperate to escape the sudden violence. Others, including several medically trained individuals who happened to be present, courageously rushed to assist Chad Oulson, who had taken a few stumbling, agonizing steps away after being shot before collapsing heavily to the floor. One moviegoer, an ICU nurse, immediately began resuscitation efforts, fighting to save his life. Nicole Oulson, despite her own painful and bleeding hand injury, managed to call 911, her voice likely trembling with shock and terror. While emergency responders arrived and desperately attended to the Oulsons, Curtis Reeves was quickly taken into custody by the first arriving uniformed police officers and placed in the back of a police cruiser. There, in the immediate aftermath of the shooting, Detective Alan Proctor from the Pasco County Sheriff's Office interviewed Curtis Reeves about the incident. Reeves, in this initial recorded statement, told police that Chad Oulson had been explosive and very aggressive. He stated, with apparent conviction, that the younger man had scared the shit out of him. The entire conversation in the cruiser was recorded, providing a crucial early account of Reeves's perspective. Reeves described Oulson as coming over him, and Reeves, pushing Oulson off, saying repeatedly, "No, no, 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 no." He claimed he had no idea what Oulson had in his hand, if anything, only that the theater was dark. He didn't know this man, and this man was aggressively coming after him. "I thought the guy was fixing to beat me up," Reeves stated plainly to the detective. Vivian Reeves, Curtis's wife, also gave a recorded statement to police shortly after the incident, although she acknowledged seeing less of the physical altercation than her husband. She did confirm hearing Chad Oulson rise from his seat and curse angrily at Curtis Reeves, allegedly saying something to the effect of, "Who the fuck do you think you are?" and then lean menacingly over towards her husband, just before the shot was heard. Tragically, Chad Oulson passed away from the single gunshot wound to his chest. Nicole Oulson required emergency medical treatment for her injured hand and would later undergo reconstructive surgery on her finger. The charge against Curtis Reeves was now presumed to be, at a minimum, second-degree murder. Crime scene investigators meticulously documented the scene in Theater 10. The casing from the fatal .380 caliber shot was found on the floor of the theater, near where Curtis Reeves had been sitting. The spilled popcorn, a stark symbol of the triviality of the initial dispute, as well as Chad Oulson's iPhone, were also found on the floor in the aisle of the last row, silent witnesses to the deadly confrontation. The very next day, Curtis Reeves made his first formal court appearance, accompanied by his prominent defense attorney, Richard Escobar. Escobar argued vehemently from the outset that his client, a decorated law enforcement veteran, had acted in legitimate self-defense and should not be considered either a flight risk or a danger to the public if released on bail. After a short hearing, however, Circuit Judge Lynn Tepper ordered that Curtis Reeves be held in the Land O'Lakes jail without the possibility of bail as he awaited further legal proceedings. A far more extensive and detailed bond hearing, one that would last over 2 full days and contain over 12 grueling hours of testimony from various witnesses, including family members and character witnesses for Reeves, was held in early February. At this crucial hearing, Curtis's daughter, Jennifer, testified under oath about her father's noticeably deteriorating physical state, strategically laying out what would become a key component of his future defense strategy. She described his increasing difficulty in simple physical tasks, such as lifting his young granddaughter, then weighing only about 26.5 pounds, and his significant struggles with mobility, like getting up from the floor after playing with the child. Despite this testimony aimed at portraying Reeves as physically frail, the judge initially ordered that he continue to be held on bail. However, Reeves's determined defense team immediately appealed that decision and eventually, successfully, won his release. In July 2014, after spending 7 months incarcerated, Curtis Reeves was released from jail on a $150,000 bail bond. The conditions of his release on house arrest were notably strict. He was required to wear a standard ankle monitor for continuous GPS tracking at all times. He was permitted to leave his home only for essential, pre-approved trips, such as visits to the grocery store, his attorney's office, attendance at religious services, and for necessary medical treatment. Crucially, as part of his bail conditions, Curtis Reeves was also ordered to surrender all firearms in his possession to the Pasco Sheriff's Office. The case, which was quickly and widely dubbed the popcorn murder by some segments of the local and national media, saw a dramatic increase in coverage during this period. With Curtis Reeves's photograph now frequently displayed in Tampa news reports and across various media platforms, he was recognized by others. A couple of fellow moviegoers from around the Tampa Bay region emerged from the woodwork with their own troubling stories of Reeves's alleged past aggressive and confrontational behavior in similar cinema settings. One man, Edward Thompson, came forward with a detailed account of being loudly screamed at by Curtis Reeves at a local cinema back in 2006, apparently over perceived talking during a movie. Evidently, the encounter with Reeves had been memorable and intimidating enough for Thompson to recall it vividly, some 8 years later. Thompson stated his belief that Reeves, on that occasion, was purposely picking a fight and attempting to force a confrontation. Another couple, Michael and Jamira Dixon, also recounted a disturbing encounter. They had been at the very same Wesley Chapel theater where Chad Oulson was killed, only weeks before the fatal incident with Oulson. They described being aggressively and repeatedly scolded by Curtis Reeves for Jamira texting on her phone during the movie previews. Jamira Dixon reported being made even more uncomfortable later when she said Reeves appeared to follow her as she exited the theater to go to the restroom. Despite what appeared on the surface as a potential pattern of aggressive behavior related to perceived disturbances in movie theaters, neither the Dixons nor Edward Thompson would ultimately be called upon by the prosecution to give testimony against Curtis Reeves at his eventual trial. Meanwhile, Nicole Oulson, now a grieving widow and a single mother, was also understandably taking advantage of the intense media attention focused on the case to tell her side of the tragic story, to give a voice to her husband, Chad. "The gunshot wound will heal," she said with quiet resilience, referring to her own injured finger. "It's a finger. The real pain is in my heart." She consistently maintained that Curtis Reeves had confronted her husband multiple times about the phone use, which Chad had initially ignored. She asserted that the situation only escalated to a point where her husband finally spoke up in his own defense, and that's precisely when Curtis Reeves shot him. Curtis Reeves's adamant claims of self-defense significantly complicated the state's ability to bring charges against him effectively and secure a conviction. Under Florida law at the time of the incident, and still a subject of much national debate, a controversial "stand your ground" statute allowed for legal immunity from prosecution, including for serious charges like murder, under certain specific circumstances. The law, in essence, states that a person has no legal duty to retreat when faced with what they reasonably perceive as a violent confrontation and can legally use deadly force if he or she reasonably fears imminent death or great bodily harm. So, in 2015, leveraging this statute, Reeves's defense team formally filed a motion to dismiss all criminal charges against him, laying out their comprehensive self-defense argument under the Stand Your Ground law. Only a few months later, Nicole Oulson and her legal counsel were also busy pursuing another avenue of accountability. They filed a civil lawsuit against Cobb Theaters, the company that owned and operated the cinema, Oakley Grove Development, the company that owned the larger complex where the cinema was located, and Thomas Peck, the general manager of the theater who had spoken with Reeves. The civil complaint asserted that Peck, and by extension the corporate entities, were demonstrably negligent for not acting more urgently or effectively when Curtis Reeves initially left the theater to complain to management about Chad Oulson's cell phone use, arguing that proper intervention at that stage could have prevented the fatal escalation. This civil lawsuit was eventually placed on hold by the courts until the more pressing criminal proceedings against Curtis Reeves could be fully worked out and adjudicated. Ultimately, it would take until December 2020 before the civil suit was formally dismissed from the court docket. Public court documents indicate that Nicole Oulson reached a private, confidential settlement with those parties named in her lawsuit. But, as is common in such agreements, no further details of that settlement are publicly available. The critical and highly anticipated Stand Your Ground immunity hearing for Curtis Reeves began in February 2017, and it was a lengthy, intensive legal proceeding lasting for 2 full weeks. The stakes were incredibly high if Reeves's legal team successfully persuaded the judge at this hearing that his actions met the criteria for Stand Your Ground immunity. He would walk free and would not have to continue to face criminal charges for Chad Oulson's murder. Over half a dozen witnesses from the movie theater that day were called to the stand to testify, each recounting, as best they could, what they remembered of the brief, chaotic, and fatally heated exchange that had preceded Curtis Reeves's single gunshot. Legal commentators offering analysis to local news outlets noted that successfully applying Stand Your Ground immunity might be difficult in an altercation where the primary perceived violent confrontation appeared to be an attack with a lightweight bag of popcorn. However, there was also a widespread acknowledgement in legal circles that the justification for the use of deadly force in defending oneself is sometimes viewed more leniently by the courts when the person claiming self-defense is deemed to be too frail, elderly, or physically compromised to respond effectively to a threat by any other, less lethal means. The .380 pistol, in this specific context, became what some legal analysts termed the great equalizer in the sudden, physical confrontation between the elderly Reeves and the younger, larger Oulson. Curtis Reeves himself took the stand at this crucial hearing, testifying under oath. I realized that I was in a life-or-death struggle, that all of a sudden he was no longer a loudmouth. He was now a very definite threat. That's when the pistol came out. At that point, it was his life or mine. After the exhaustive 2 weeks of testimony, witness cross-examinations, and detailed legal arguments from both the defense and the prosecution, Judge Susan Barthel issued her ruling. She issued an order unequivocally denying Curtis Reeves's request for immunity from prosecution under the Stand Your Ground law. In her written decision, Judge Barthel stated that, based on her review of all the evidence presented, including the crucial video security footage from inside the theater, She believed that Curtis Reeves was not, in fact, in reasonable fear of imminent death or great bodily harm at the moment he chose to fire the shot. Much would still be said and argued about that particular piece of video evidence during the subsequent trial. But as for the legal threshold required by the Stand Your Ground statute, Judge Barthel firmly ruled that Curtis Reeves did not meet it. This pivotal decision meant that the murder charges against him could and would proceed, and he would ultimately have to face a jury trial for the killing of Chad Oulson. After several years of legally imposed delays and procedural wrangling already, many who were closely involved in the case, or observing it, began to express sincere doubt that Curtis Reeves, given his advanced age and the slow pace of the justice system, might never actually face a full trial at all. Curtis Reeves was almost 75 years old at this particular point in the proceedings and was still out on bond under house arrest. As some legal observers predicted, Judge Barthel's critical decision denying immunity was promptly appealed by Reeves's defense team, a legal maneuver that served to further delay any potential murder trial. In May 2018, the District Court of Appeals declined to reverse Judge Barthel's decision, thereby upholding the denial of Stand Your Ground immunity and clearing the path, however slowly, towards a trial. When the murder trial of Curtis Reeves finally commenced, years after the fatal shooting in the movie theater, the central assertion from the prosecution was stark and deeply unsettling. Chad Oulson had lost his life over nothing more than a trivial argument about popcorn. The prosecution argued that Curtis Reeves, a highly trained and experienced former law enforcement officer, had knowingly and illegally brought a loaded firearm into the theater and then, in a fit of anger or pique, had shot and killed another person after merely having some popcorn tossed on him. They repeatedly emphasized Curtis Reeves's own statement, captured on police recordings immediately after the shooting, where he allegedly said something to the effect of, "Throw popcorn in my face," as direct evidence of his mindset and perhaps his disproportionate reaction. They urged the jury to watch the grainy theater video, however flawed, which they claimed showed the popcorn suddenly in the air and then, almost instantaneously, the fatal shot, seemingly fired from Reeves's hip without true deliberation or imminent threat. The defense, led by Richard Escobar, presented a multifaceted argument, contending that a complex combination of two significant factors were at play during that brief, fatal altercation. Firstly, they contended that Curtis Reeves's decades of extensive experience and specialized knowledge in law enforcement, including his SWAT team background, had profoundly informed his understanding and perception of the potential threat that Chad Oulson, a younger, larger, and seemingly aggressive man, posed to him in that confined, dark space. Reeves, they argued, knew far better than most ordinary people how damaging and potentially life-threatening even a single, well-placed, closed-fisted hit could be, especially to an elderly and physically vulnerable person like himself. Secondly, the defense emphasized that after so many years in the demanding fields of policing and corporate security, the cumulative toll of time and old injuries had undeniably caught up with the elderly man. He was, they claimed with supporting medical and personal testimony, in far worse physical shape than he perhaps outwardly appeared. And this deeply ingrained knowledge of his own escalating physical limitations made him feel extremely vulnerable, and thus more easily and reasonably threatened by Oulson's actions. To understand the crucial context of self-defense in this specific case, the jury was repeatedly asked by the defense to try and place themselves in Curtis Reeves's shoes, a 71-year-old man, professionally trained in threat assessment and response, but now physically compromised and feeling cornered, facing what he perceived as an aggressive, unpredictable younger man in a dark, enclosed movie theater. To counter the narrative that Curtis Reeves was merely a passive victim, the prosecution introduced witnesses like Charles Cummings. Cummings testified that Curtis Reeves was so visibly worked up and agitated after the initial verbal exchange with Chad Oulson that, As Reeves was angrily leaving Theater 10 to find the manager, he forcefully bumped into Cummings while trying to move past his seat down the narrow aisle and didn't even acknowledge the contact or offer an apology, suggesting a high level of agitation. However, once out at the theater's service desk, another witness, Dawn Simpson, observed Curtis Reeves waiting patiently and calmly for his turn to speak with the manager. Thomas Peck himself, when he testified, confirmed this version of events, stating that Curtis Reeves was not visibly upset or agitated when he spoke to him, and was generally polite in lodging his complaint about the cell phone. In fact, Peck testified that he didn't even feel the need to accompany the older man back into the theater to address the issue with Oulson directly, precisely because he did not perceive the incident, as described by Reeves, as being particularly noteworthy, urgent, or indicative of a serious ongoing conflict. The defense, in turn, made efforts to frame Chad Oulson as the primary aggressor in the fatal confrontation, partly by highlighting his alleged use of obscenities towards the Reeveses during the argument. In his recorded statement to police immediately after the shooting, Curtis Reeves had claimed that the F-word was used towards him aggressively 3 to 4 times by Oulson, and that he found this language threatening. Reeves reiterated this claim when he took the stand in his own defense at his trial. However, Nicole Oulson, Chad's widow, testified at the trial that she did not hear her husband direct any F-bombs or similarly profane language towards the man seated behind them. Another witness who was present in the theater recalled hearing Oulson say something along the lines of "texting my daughter," in what she described as an annoyed voice, but she couldn't make out any other specific words or profanities. The low-quality security camera footage from inside the theater, unfortunately, was of very limited help in definitively resolving these crucial testimonial discrepancies. As previously noted, it only partially depicted the actual shooting incident and, critically, it had no audio track whatsoever. The cameras were positioned on either side of the theater but were primarily set up to capture the back portion of the seating area, specifically the area behind the dividing wall where the Reeveses were sitting. There were no cameras in place that could capture a clear view of the main seating area where the Oulsons were located. Furthermore, the resolution of the available footage was described by all parties as being awful, making it difficult to discern fine details or movements with any certainty. A central point of intense curiosity and legal contention in the video was a faint, fleeting reflection that was caught by one of the cameras only a moment or two before the popcorn was thrown by Oulson. If Curtis Reeves's testimony at trial was to be believed, that enigmatic reflection could have been caused by the bright screen of Chad Oulson's cell phone, as it was allegedly being thrown directly at his head by Oulson. Reeves testified that he suddenly saw a flash of a reflection. Then everything went kind of fuzzy, and he firmly believed that he had been hit on his glasses, specifically on the top left side. It is a fact that Chad Oulson's cell phone was indeed found on the floor by Curtis Reeves's feet after the shooting. Additionally, a visible red mark was observed on Curtis Reeves's head, above his left eye, in photographs that were taken later that day. Further supporting this claim, one moviegoer witness, Joanna Turner, testified that she thought she saw something being thrown by Chad Oulson at Curtis Reeves before Chad started throwing the popcorn. She initially thought that maybe it was a mug or some kind of thermos container, but in retrospect, she conceded that it might indeed have been a cell phone. The defense team also called several expert witnesses to bolster their self-defense claim. Dr. Donna Cohen, a professor from the University of South Florida and a recognized expert in the field of aging, testified to the jury that as a person ages, they generally and genuinely feel more vulnerable, especially when they perceive themselves to be threatened. And their reactions to such perceived threats can differ significantly from those of younger individuals. Roy Bedard, a highly experienced law enforcement trainer and an expert in the complex field of human decision-making under extreme pressure, particularly for those individuals, like Curtis Reeves, who have been extensively trained and have long experience in law enforcement, also provided key testimony. He explained to the jury that decisions made in high-stress, rapidly evolving situations must be viewed in light of the totality of the circumstances as perceived by the individual at that precise moment. By this, he meant that absolutely everything in the immediate environment, from the ambient level of lighting impacting vision, the levels of sound affecting hearing and situational awareness, to how old someone is and, by direct extension, how physically capable or inherently vulnerable they are if they are faced with a sudden physical altercation, will inevitably feed into the complex reasoning process behind any decision made under such intense pressure. Bedard also testified that, as a general psychological principle, the less concrete information you have about a perceived threat in front of you, the more likely you are to instinctively assume a worst-case scenario, preparing for the highest level of potential danger. At his trial, Curtis Reeves was technically facing 3 distinct criminal charges: second-degree murder for the death of Chad Oulson, a lesser-included charge of manslaughter, also for Chad Oulson's death, and a separate charge of aggravated battery for the significant injury caused to Nicole Oulson's hand by the same bullet. On February 25, 2022, after 8 long and arduous years since the fatal shooting in the movie theater, the jury, having heard all the evidence and testimony, returned its verdict. Curtis Reeves was found not guilty on all 3 counts. Observers in the courtroom reported appearing visibly surprised, but the room remained quiet while the solemn verdict was read by the court clerk. Those who disagreed with the jury's decision, including prosecutors and Chad Oulson's family, claimed that defense counsel Richard Escobar and Reeves's other attorneys had successfully, and perhaps cynically, argued to the jury that Reeves shouldn't go to jail primarily because he was simply an old and frail man, rather than basing their verdict strictly on the objective facts of the case or the applicable law regarding self-defense. Curtis Reeves walked out of the courtroom a free man, acquitted on all charges, his actions on that tragic afternoon deemed legally justifiable by a jury of his peers. For Chad Oulson's grieving family, particularly his wife Nicole and his young daughter Alexis, who would now grow up without her father, the verdict was undoubtedly a devastating and painful end to an incredibly protracted 8-year ordeal. A seemingly trivial argument over the use of a cell phone in a public place, a thrown bag of popcorn in a moment of anger, and a retired police captain's readily accessible .380 pistol converged in the darkness of a movie theater to tragically end one life and irrevocably alter the course of many others. Was it, in the final analysis, a tragic but legitimate act of self-preservation by a genuinely vulnerable senior citizen, or was it an avoidable, disproportionate overreaction, perhaps fueled by simmering anger and a lifetime spent in the often confrontational world of law enforcement? The jury has spoken, delivering its legal conclusion, but the wider public debate and the private grief surrounding the so-called popcorn murder will likely continue for many years to come. I'm David, and this has been Crime Line. We'll see you for our next investigation.